The first day of law school used to be a big deal. We should get back to treating it that way. 90 years ago, the orientation speech at Columbia Law School lasted 8 hours, spanned 2 days, and included a 100-page handout. In 1984, ours lasted about an hour. The professor who walked to the podium had an Abe Lincoln beard, so expectations rose. Then he said essentially this: we can't teach you what the law is, because there are too many laws, and they change all the time. But we can teach you how to think like a lawyer. What thinking like a lawyer was, he didn't say. What a letdown. And the sheer begging of the question. It was like first and 10, and he punted. Imagine getting a fortune cookie from this guy. It would say, one day your fortune will reveal important truths. Well, how about now? And anyone could have given that speech. Imagine yourself at Harvard Medical School tomorrow, Grey's Anatomy in one hand, welcoming the new class and saying, over the next 4 years, we can't teach you how to be the world's top heart surgeon, but we can teach you how to think like a doctor. Would they nod and take it? Maybe, but I sensed something was rotten. We paid admission to a select group, were ready to live like monks, and expected to hear things only tuition could buy. And the Lincoln Beard fellow had all summer to prepare. It was as if he scratched something on an envelope, but it was no Gettysburg Address. He turned out to be a decent teacher, though. He died recently, which prompted this look back. His obituary said he majored in English. Aha! As a rule, I think those chosen to give the orientation speech should have backgrounds in philosophy, economics, or teach the class in jurisprudence. Theory is needed. In 1930, Columbia Law School selected a legal scholar to give their orientation speech, Carl Llewellyn, the future author of the Uniform Commercial Code. Every orientation speaker since then should read his speech. It was published as a book, The Bramble Bush. Unfortunately, its insights are larded with preamble, tangent, and repetition, which make it tedious. It's as if his loyalties were also slightly off his true audience, those paying tuition. Students are desperate to learn one thing at orientation: how to get A's in their courses. To do that, they must first learn legal method. We had a 3-week mini-course on it before we began contracts, torts, property, criminal law, and legal skills. It consists mostly of learning how to extract rules of law from the common law, which is case law, the law created by judges in their written opinions. Legislatures enact statutes, which can only be stated one way, as written, but rules from cases can be expressed narrowly or broadly, an art. Some cases are also instructive as models of legal reasoning and writing. In our mini-course, we were taught 1. Basic legal terminology, 2. The hierarchy of legal authority, constitutions, statutes, administrative regulations, cases, and court rules, federal and state, with federal laws ranking higher, 3. How to brief a case, which is essentially summarizing it and stating its rule of law, called its holding, and 4. How to combine holdings, known as case law synthesis, to form a mini body of law that can be applied to real life and to hypothetical cases. Found in the essay Questions on Law School Exams and on Bar Exams. Our first semester gave the appearance of learning from assigning lots of homework. We had to brief about 5 cases per night. When the opinions are long, it's tedious work and constitutes the chief source of drudgery in the life of a law student. Class deadlines lead to reading cases quickly, so the quality of the briefs is usually mediocre. And we lacked a tangible criterion of correctness because the professors did not show us their briefs, probably partly from laziness, from imitating how they were taught, and from an unwillingness to risk getting it wrong. It's an everyday agency cost of education, a professor putting his personal convenience ahead of his principles. It's a hidden cost in all schools and manifests itself in things you may have noticed in high school and college, self-indulgent lectures that are non-rigorous and that easily wander off topic. Our professors said a brief of a case should consist of 5 sections: facts, issue, holding, rationale, and comment. Llewellyn asked for 12 sections in each brief. LexisNexis.com offers ready-made briefs online, which use these sections: rule, facts, issue, answer, conclusion. And CaseBriefs.com goes with brief fact summary, synopsis of rule of law, issue, held, discussion. So, it's a varied art. An alternative to those models which I haven't seen mentioned yet, but which makes sense and proves its worth, you may find, is to use headings that correspond to the actual structure of the court's opinion. If it starts with the facts, do the same. If with the issue, do that. No need to change it. After all, you are briefing that particular case. So why not reflect its organization? Otherwise, you will waste too much time on classification dilemmas and make heading mistakes. Late in my first semester, one student thought the rationale section of the brief meant the reasoning of the court, which is a valid sense of rationale. But the professor said that if she still didn't know what that word meant, she may be in trouble on the exam. He had meant rationale in the sense of what social evil or mischief does the rule of law disincentivize, such that it's a good rule. Yet, he didn't even acknowledge the semantic ambiguity in the term as a source of confusion, but left her hanging. What an educator! And he graduated from Harvard. So, don't put your law professors on a pedestal, because there's a 99% chance they don't deserve it. And remember what a wise professor once said, law students teach themselves the law. So don't wait for someone to do it for you. It won't happen. But, with a few good cases, you can teach yourself about legal method and legal reasoning before ever arriving at orientation. Start by reading Trammell v. U.S., 1980. It helps to use Llewellyn's tip of dramatizing the facts of each case, to make them vivid and memorable, and to ask yourself what each party wants and why. Otis Trammell conspired with his wife Elizabeth, and others, to smuggle heroin into the USA. After the couple made a successful run to the Philippines, he sent her to Thailand alone. On the way back, she was caught by customs in Hawaii with 4 ounces of heroin. To avoid prosecution as a drug smuggler, she told the truth about her husband's criminal scheme. She spoke of things she saw and heard in front of others, not private matters between husband and wife, pillow talk, which is inadmissible as confidential communications. Based on his wife's testimony, Mr. Trammell was convicted of conspiracy to smuggle drugs. His attempt to bar her testimony, the primary evidence against him, based on the marital privilege, failed. The privilege was rooted in the ancient notion that a wife has no separate legal identity. In 1933, the court in Funk v. U.S. eroded the privilege and ruled that a wife could testify on behalf of her husband with his consent. The issue of testifying against him was not addressed in Funk, but was in Hawkins v. U.S., 1958, in which the court reasoned that permitting the wife to testify against her husband, and against his wishes, could harm a marriage, so it was not permitted. Back then, family ties were strong, and it would be outrageous to see Ozzie convicted by Harriet. Yet, despite the precedent of Hawkins, the lower courts nonetheless permitted Elizabeth Trammell's testimony over her husband's objection. They treated their marital status as collateral to the need of obtaining the testimony of an unindicted co-conspirator against the criminal mastermind, in order to punish a crime. In Trammell, the Supreme Court essentially overruled Hawkins and affirmed the conviction of a husband on the testimony of his wife. Chief Justice Burger noted that laws sometimes persist after the reasons for them have disappeared, and a long-standing principle of jurisprudence says that a rule should not extend beyond its rationale. The ancient justification for the marital privilege was gone, and the modern justification of preserving marital harmony seemed like an empty form of words, because if she were willing to testify against him, then scant marital harmony must exist already. So, on balance, it was absurd to exalt a mere form of words at the cost of silencing the truth and thwarting justice. The most cogent point in the opinion concerned what would happen if we applied the rule in Hawkins to the Trammell household. It would shield him from conviction by excluding her testimony. But that results in grave damage to marital harmony too, because she'd receive no leniency, get convicted as a drug mule, and he'd go scot-free, despite being the criminal mastermind. Resentment, not marital bliss, would result. So, the decision was 9-0, with Justice Stewart concurring, agreeing with the decision, but for other reasons. Stewart thought the majority were less than honest to portray the world as so changed since 1958, when he was on the bench and heard the same arguments in Hawkins, and also wrote a concurring opinion then. The symbol of Lady Justice blindfolded, with scales and a sword, may portray the nature of a legal problem better than the staff of Asclepius does a medical one, but important things are still missing. What goes on the scales? Justice Cardozo, one of the most respected judges in American history, would say it's the conflicting social interests. Deciding a case impedes one party's interest. He said that generally, the social interest served by symmetry or certainty must be balanced against the social interest served by equity and fairness or other element of social justice. We want laws that produce just results, not laws that create traps for the unwary or that punish basic human nature. If a law is a path to an unjust result, then what good is it? Ultimately, the scales should tip by determining which ruling will produce a better world in which to live. The etymology of jurisprudence reveals a focus on the future also, law, juris, plus a foreseeing, prudentia. Jeremy Bentham, for example, foresaw, over a century before Hawkins, that a marital privilege for the accused could lead to abuses and thwart justice in situations similar to Trammell. Law students are taught that their appellate briefs should look to the past, the present, and the future. Why the future? The idea relates to Kant's way to assess the ethical value of a maxim of behavior. Ask if you would want to live in a world in which your maxim became a universal law. It's a thought experiment that puts one on the potential receiving end of the policy someday, similar to legislating behind a hypothetical veil of ignorance as to one's future position in society. Example, drafting landlord/tenant law without regard to which one you would be. To be content is either, the rules must be fair to both sides. Now we are getting to the heart of what makes a law just. How did Abraham make peace with Lot as they and their herdsmen began to fight to survive on the same area of land? The same way a parent decides how two kids should divide a cake fairly. One cuts it, and the other chooses. Why does this create justice? Because one is forced to cut behind a veil of ignorance. If you cut it unfairly, you will suffer the consequence. And a legislator who is a landlord may one day be a tenant. It's about creating the proper incentives to assure fair outcomes for all. Recall how a lawmaker in Babylon, around 1760 BC, tried to make sure his people lived in homes that would not collapse from negligent construction. He posted a law that said if a house collapses from negligent construction and kills the homeowner, then the home builder shall be put to death. People slept safe in their homes, knowing the builder's life depended on it. Justice Scalia came up with a helpful simile for judicial reasoning to know as well. He said his job was like trying to determine whether a line is longer than a rock is heavy. In Trammell, the line is the precedent that appears controlling, the rule of marital privilege in Hawkins. On closer examination, that line has a weak rationale, so it shrinks in length. The rock is the societal benefit from 1. Giving criminal courts access to the most relevant, probative evidence, 2. Having the truth discovered, and 3. Having crimes punished and justice done. When such a heavy rock meets such a short line, the rock wins, in effect, mindful that weight and length cannot be measured along the same dimension. But Scalia would say that shows the difficulty of the problem, comparing societal benefits of different kinds against each other and choosing the best trade-off for optimal outcomes for society going forward. It's a matter of delicate judgment, as Bobby Fischer said of his ability to discern a good move in chess. Chess is also a matter of predicting beneficial outcomes. Assessments often differ, and the Supreme Court is sometimes split 5-4. The ruling in Trammell also illustrates Justice Oliver Wendell Holmes's definition of the law. He said it is a prediction of what the courts will do in your case. The attorney for Mr. Trammell was probably confident the courts would follow the precedent in Hawkins, which made it clear that the defendant's spouse could exclude his spouse's adverse testimony. Yet, Holmes had learned how unpredictable the application of any one law may be in a given case. Certain facts may be assigned greater weight in the future, as may some maxims of jurisprudence, such as, in Trammell, that a rule should not be applied beyond its rationale, and applying ancient precedent may produce an unjust result that the court seeks to avoid, especially if the culture has changed. So, a legal result, which seemed so certain, fails to occur. The lawyer who has his finger on the pulse of society may see a winnable case that others miss, because he senses its time has come. After studying Trammell, you are then in a position to assess the merits of online briefs. In LexisNexis, the issue in Trammell was worded, was the testimony of petitioner's wife inadmissible because it was protected by spousal privilege? This question is too indeterminate to be answered, because material facts are left out, such as whether the husband objected at trial, or if the testimony concerned confidential communications. An issue on appeal could be so broadly stated as to be unanswerable by itself yet fit every case, including Trammell, should the ruling of the lower court be affirmed. A well-formed issue, however, includes sufficient facts to be answered on its own. That takes work, though, and even Chief Justice Burger took a shortcut with his statement of the issue, whether an accused may invoke the privilege against adverse spousal testimony so as to exclude the voluntary testimony of his wife. That's worded better than the issue in LexisNexis, but Burger should have included this at the end, concerning non-confidential communications. When the issue, which is simply the legal question before the court, contains all the material facts of the case, then the holding is just the answer to that question in the affirmative or negative with all the material facts included. Yet, note that the lower court saw the issue differently, whether the ruling in Hawkins barred the voluntary testimony of a spouse who appears as an unindicted co-conspirator under grant of immunity from the government in return for her testimony. That wording stressed facts outside their marital relation. And Case Briefs simply copies Burger's wording of the issue, without using quotation marks, so you can't tell if it's quoted matter or paraphrased until you see the case. The brief by Case Briefs also suffers from category confusion and repetition. It puts the holding under the heading Synopsis of the Rule of Law and then again under the section Held, which proves to be a misnomer, since it is full of things other than the holding, for paragraphs concerning the history of the law, its rationale, the court's reasoning, and the application of the law. So, they can't stick to their own headings, and you don't know what is to be found where. Trammell was briefed better overall, however, by Case Briefs than by LexisNexis, which failed to mention anywhere that Trammell concerned non-confidential marital communications. So, you now see firsthand the danger of relying on canned briefs online. They are often misworded and disorganized, but are all right to look at after you have briefed a case. If you brief Trammell according to the sequence of its content, as suggested earlier, then you have no problem determining the headings, which look like this. State the issue first, then give the facts and procedural posture. Next, state the history of the law, its application, and the holding. Then, summarize the concurrence. In Riggs v. Palmer, New York, 1889, the highest court of New York, the Court of Appeals, was faced with a dilemma. Grandfather Palmer owned a farm and wrote a will in which his 16-year-old grandson Elmer received more than his daughters did. The grandfather then changed his mind and said he would cut Elmer out of the will. When Elmer learned this, he decided to kill his grandfather with poison before the will could be changed. Elmer was convicted of murder and sent to a juvenile reformatory. The grandfather's daughters, Mrs. Riggs and her sister, challenged the legality of what Elmer received under the will. Judge Earl, writing for the majority, said that if the statutes were literally construed, then Elmer would get what the will gave him. But a rational interpretation of a statute, as well as an equitable construction of one, permits deviating from the letter of the law to give force to the probable intention of the lawmakers, in which case Elmer would not take under the will. In addition, the judge stated that all laws as well as all contracts may be controlled in their operation and effect by general, fundamental maxims of the common law, such as that a person should not profit from his own wrong. The judge analogized a case that denied life insurance money to a beneficiary who committed murder to get it. The court held that because Elmer committed murder to obtain property, legal title never passed to him. So, the property remained in the grandfather's estate to pass to his other beneficiaries, such as Mrs. Riggs. Scalia's metaphor fits this case. Two things combine in the line: 1, following the statute of wills and doing as it says, and 2, not issuing a fine, as a criminal court might, by taking away what the will gave Elmer. The rock is the inequity of letting someone profit from their own wrong, i.e., the sentiment that crime should not pay. The majority opinion says the rock is heavier than the line is long. And their opinion seems right. Until you read the dissent, which is also persuasive. Judge Gray, joined in dissent by Judge Danforth, reminds us that statutes control how a will shall be made and revoked, with no power to alter a will's provisions bestowed upon the courts. The statutes expressly close the door to such escape hatches: no will in writing shall be revoked or altered otherwise than as the statute provides. At most, the court may recommend legislation, example, propose a bill that says murdering the testator prevents one from taking under his will. Plus, a criminal court decides the punishment for murder, not a probate court. The dissent sees no room for activism. Gray likens the majority opinion to rewriting the old man's will. It renders wills uncertain and opens the door to sob stories by jilted beneficiaries who plead for equitable relief in court. The dissent shows how a judicial philosophy, seeing the role of the courts vis-a-vis the legislature slightly differently, leads to the opposite conclusion. The leitmotif of activism versus restraint on the bench continues to this day. In Riggs, the dissent calls for restraint. In the next case, the dissent calls for activism. Could it be the very same judge writing both dissents, years apart? Yes. Louis Brandeis did so well in high school that he went straight into Harvard Law School at age 18, where he graduated first in his class, in 1877, with a GPA of 97, the highest GPA ever recorded there. His record apparently stood until 1997. In Boston, he formed a law firm with the man who graduated second in their class, Samuel Warren, and the two published a Model Law Review article in 1890. It called for the law to protect the persona, or personality, of people given the proliferation of cameras, peeping toms, and the tabloid press. They argued that several cases in England had already upheld the right to privacy in substance, but not in name. In the first 2 pages of their article, you will see the masters touch as they make good sense of tort law while taking a broad perspective.
The common law is a mirror of the friction in society. Courts decide controversies that arise from the rough and tumble of life. In the USA, it took several years for the right to privacy to be in strong dispute. The case was Roberson v. Rochester Folding Box Company, New York, 1902, a case of first impression. In 1897, at age 14, Abigail Roberson sat for photographs in Rochester, New York, the headquarters of Kodak. She gave a profile shot of herself to her boyfriend, who worked for a local business, Rochester Folding Box. Evidently, he showed it to his bosses, because they printed it on an advertisement which they ran for Franklin Mills Flour with flour of the family above her head. Abigail had been a sickly child. A doctor said she had one lung and a bad heart, and her mother had sometimes introduced her as her invalid. One day while in a grocery store in Vermont, Abigail saw the ad for flour with her picture on it and claimed to be so upset that she became bedridden. She learned 25,000 copies of the ad were made and claimed she was recognized in public as the flour girl and teased. Her father had died when she was 9, and her mother, a mother of 6 and in her 40s, contacted a lawyer and sued for the then huge sum of $15,000 for the unauthorized use of her photo. But, apparently, to portray Abigail as an innocent victim, her lawyer never mentioned, if he was even told, that she had given the photo to an employee of the defendant company, her boyfriend. That omission probably cost her the case. She was non-suited in 1902 for failing to state a cause of action. Her mother died that same year, perhaps devastated by the lost financial opportunity. Abigail proved not to be so sickly after all and lived to age 94. She never married and played piano in silent movie theaters. The courts were not informed how her photo was acquired and used beyond the scope of her consent, if it was, in fact. No one knows what she and her boyfriend had agreed upon. However, had the pleadings stated how the photo, a piece of her private property, was given and misappropriated, then her case would be analogous to English cases which had compensated harm stemming from misappropriated intangible property such as private etchings, recipes, letters, and lectures. So the majority could have hung its hat on a breach of confidence, of trust, or the like. As it was, the court was split 4-3 against Abigail. The majority practiced restraint while foreseeing, albeit wrongly, a flood of litigation that would hamstring the press and even one's right to gossip if a right to privacy was announced as a new legal principle. They suggested the legislature could act in a more limited capacity to target the abuse, which it did soon after, in the wake of public outrage over their holding in Roberson. The dissent argued that regardless of how the defendant acquired the photo, it was used without her consent, which was an invasion of her right to privacy, given that if anyone had a right to her face, it was her and no one else. Notice that Judge Gray, who had written the dissent in Riggs over 10 years prior, also wrote the dissent in Roberson, but he displayed a different judicial temperament this time. He had advocated judicial restraint in Riggs in deference to the legislature. In Roberson, he did not want to defer to the legislature, but wanted the court to find a right to privacy in the common law. Whereas, Judge Parker, writing for the majority, was not convinced by Brandeis's article that a right to privacy should exist in common law. 3 years later, the High Court of Georgia was convinced, however, and Gray's dissent in Roberson, in effect, became the law of Georgia, and in most states thereafter. Today, Judge Parker's forecast of doom from a right to privacy reveals him to have been a poor jurisprudent, as his foresight of the societal consequences of the dissent's proposed ruling was terrible. He could have crafted a narrow holding but may have thought the plaintiff's injuries were too suspicious to deserve compensation. Maybe the facts of her case simply did not move him. By a twist of fate, Judge Parker ran for president in 1904 and was bothered by the Kodak fiends, as they were called, taking his picture on the street. He wanted his privacy. Abigail Robertson took the opportunity to remind him in an open letter, which was printed on the front page of the New York Times, that there was no right to privacy in New York. Now let's look at a case that illustrates the saying that the law is like last year's clothes on a growing child. McPherson v. Buick Motor Corporation, New York, 1916. It's the most frequently assigned case in law school and a milestone in the law of products liability. A British precedent from 1842 had limited liability for negligent maintenance of stagecoaches to the parties to the contract. Strangers to the contract who were injured by such negligence had no case. The idea was that accidents happen, stagecoaches may fail over time. When accidents happen, damages generally lie where they fall. A duty in law existed independent of contract only for inherently dangerous products, such as a mislabeled poison. This exception was expanded over time to include things that became dangerous when negligently made, such as a 90-foot scaffold, a large coffee urn, and bottles of soda water. Buick manufactured a car that could go 50 miles per hour, and in the early days of travel by car, before seatbelts, safety glass, and cushioned interiors, minor collisions caused serious injuries. McPherson was driving his neighbor to a doctor when the wood spokes of his front tire crumbled, and although only going about 8 miles per hour, the car veered off the road into a ditch. He got hurt, and his passenger was ejected. He prevailed at trial in a claim of negligence against Buick despite having no contract with them directly himself. On appeal, Chief Judge Bartlett argued in a lone dissent that the car was like a stagecoach at 8 miles per hour and not inherently dangerous, so the manufacturer, Buick, owed no duty apart from its contractual duty to the car dealer. Judge Cardozo, writing for the majority, disagreed. He thought that a jurisprudence reliant on verbal niceties of what is inherently dangerous misses the proper function of the law in society, when such a serious and foreseeable danger to others from negligent car inspection occurs. Buick knew darn well its car would be used by someone not a party to its contract with the car dealer, who only bought it for resale, and given the likelihood of serious injury to the occupants, if the car were defectively made, then Buick owed them a duty of care by law, in tort, which they breached by failing to inspect those tires before turning the car loose on the world. Buick is also a model of legal writing. Cardozo was a pillar of American jurisprudence, along with Holmes and Brandeis. He was considered the leading state judge of his time and the one qualified to fill Holmes's seat, and join Brandeis, on the Supreme Court, in 1932. If you become familiar with only the works of Holmes, Brandeis, and Cardozo, you will be ahead of most law students and of many lawyers. Cardozo wrote Buick in only his second year on the bench, after 23 years as a lawyer. Like Brandeis, he joined the bar at age 21. Such youth is non-existent in the bar today. Most people don't even start law school until after age 21. Holmes fought in the Civil War for 3 years before starting law school and joined the bar at the now typical age of 26. By 26, Cardozo had already argued 24 appeals in New York, including 8 before the state's highest court. Cardozo was a prodigy in law, a judge's son. He had a great memory and was the youngest student at Columbia University when he was age 15. In Buick, Cardozo distinguishes and analogizes cases succinctly and demonstrates a judicial philosophy known as legal realism, also called sociological jurisprudence, which were revolts against legal formalism. Formalism was apparent in Bartlett's dissent, and it still exists to this day, whenever laws are applied in an overly mechanical way. 5 years after Buick, Cardozo lectured at Yale on how he decides cases. Such a confession from the bench was unheard of at the time and received standing ovations. He said he looks to the close precedents, to legal history, to modern customs and mores, and, most importantly, to the social utility of a prospective rule of law. Imagine a case as plate tectonics. The tension in the Earth's crust is resolved when one plate slides under another. In deciding which plate goes under, Cardozo generally favored the common sense of the plain man and valued a just result over the niceties of a lexicographer or a Euclid, the formalists, who tend to ignore the bad incentives a decision may create. Assessing such incentives was the faculty of mind Holmes most prized in a judge. Holmes considered Justice Shaw's holding in Brown v. Kendall, Massachusetts, 1850, to be a model of judicial thinking. Shaw basically made the world a safer place for his people to walk the street by removing the threat of being hauled into court as defendants in personal injury cases with the burden of proving they themselves acted carefully. And as Shaw made the streets safer to walk, in Brown, Cardozo made them safer to drive, in Buick. This connection between Buick and Brown was never mentioned by any law professor at my school, nor have I seen it in any law book, but it's the sort of inference to get into the habit of making on your own. Trust your own powers of inference and don't wait for someone else to say it first, or you'll wind up hamstrung by your education, as James Randi warned us at the outset. Also, do not expect the best traits of a lawyer to be taught in law school. Some expect to be transformed by a Juris Doctor degree as the Scarecrow was by a diploma in The Wizard of Oz. That's magical thinking. A law degree can't give you the temperament of Racehorse Haynes, the tenacity of Vincent Bugliosi, the courage of Alan Dershowitz, the charisma of Jerry Spence, or the imagination of Lisa Groh, the Utah chemistry major who set academic records at Harvard Law School. Meanwhile, the chief judge, from whom we might expect the wisest of counsel, wrote a dissent in Buick that makes him look unwise, as the dissent in the famous Flying Squib case of Scott v. Shepherd, England, 1773, makes the eminent legal historian Sir William Blackstone look unwise. They each illustrate how the most learned judges may cling to stale dogmas and become an impediment to the rational growth of the law. As Cardozo expanded the law of negligence in Buick, so did Chief Justice Rose Bird in Yaircorp v. Gregory, California, 1979. Bird even relied on a California case that cited Buick. And if the facts in Yair were ever to appear on an exam, her opinion shows you what an A answer looks like. It's a model of how to apply a multi-pronged legal standard to the facts in a logical and orderly way. Let's look at this case from the plaintiff's perspective for a better understanding of it. Imagine leasing restaurant space owned by the county at an airport. The place is in bad shape. It needs remodeling and a new heating and air conditioning system. The county agrees to fix it up and hires a contractor to do it. He's a dud. He foot drags, and you are shut down for a month while awaiting simple work to be done. Then when you reopen, the heating and air conditioning still don't work. The place is either too hot or cold for many more weeks. You lose customers, revenue to cover expenses, and profits. You want to sue the contractor for $50,000. The contractor says his contract is with the government, not you, and the contract contains no time deadline. So, he refuses to compensate you and doesn't expect a court to make him, since you suffered no injury to your person nor damage to your property. He tells you your case is speculation of economic loss by an outsider to the contract, so you won't have a leg to stand on in court. You see a lawyer who informs you there is no case with facts exactly like yours upon which to rely in court, but tells you about a case in which a notary public practiced law without a license 20 years ago. The notary agreed to prepare a will in which one sister would receive all of her brother's estate. But the notary merely notarized the brother's signature on the will and did not have two witnesses sign it in the presence of the brother and of each other, as the statute requires. After the brother died, the will was thrown out of court by the judge as improperly witnessed. So, the sister only received 1/8 of her brother's estate, by the law of intestacy, no will. She sued the notary for the remaining 7/8, the amount his mistake cost her, and won. You tell the lawyer, what does this dumb notary have to do with my restaurant? This case is out in left field. I can't pay good money to proceed if this is all we have to go on. Your lawyer has been practicing law for 27 years and tells you that if you retain his services, he can make the notary case work for you by what lawyers call analogizing its material facts. He has a female co-counsel in her first year of practice who will assist him, even if they must take it to the state's highest court. So, you retain their services, see. The case eventually argued before that court, and wait for the judge's decision. The judge is a 42-year-old former deputy public defender, Rose Bird, in only her second year on the bench. She is known for voting her conscience. She reverses the lower court's dismissal of your count in negligence and says, a cause of action has been stated for negligent interference with prospective economic advantage. Bird notes that injury to one's business may be more harmful than injury to one's person or property. The rule of law the court applied consists not of specific facts, such as drafting a will and renovating a restaurant, but of abstracted facts called essential or material facts in law, which cover an open set of specific facts. The material facts in a rule are categories, analogous to a set in logic that may have many elements. How is the notary and biconja like the building contractor in Yair? They are both people that, while performing a contract, are also engaged in an activity that will cause another obvious financial loss if performed negligently. Tort law aims to protect people and their property interests by shifting the cost of an injury from the victim to the one whose negligence caused it, because leaving the victim to suffer both the injury and its cost, while the perpetrator suffers neither, is felt to be unjust. The common law contains maxims of jurisprudence, two of which could have been used in Buick and Yare, in retrospect, because they undergird each holding, but not 1 in 100 judges or professors seem to be aware of them, or they would be mentioned in those cases, the classrooms, or in the legal commentary. Holmes said, "One mark of a great lawyer is that he sees the application of the broadest rules. First, every wrong should have a remedy. Second, no one should suffer by the act of another." Notice that these maxims are legal principles which stand at a higher level of generality than rules do and carry jurisprudential weight in how rules are to be applied. We already saw how powerful a legal maxim can be in Riggs. The maxim that no one should profit from their own wrong even overcame the wording of the statute of wills. And, in Trammell, the maxim in the air was not to apply a rule beyond its rationale. That's why those cases were selected. Students, lawyers, and judges overlook legal maxims at their peril. Carl Llewellyn warned that the saddest trap for a law student is to focus on briefing each case. He thought it atomized learning, and the student should write a digest of many case holdings, something we did but called it writing a course outline. But just as briefing cases is insufficient preparation for doing well on exams, so is writing an outline. Exam taking is a separate skill. So, I say Llewellyn has led you into the second saddest trap for law students with his focus on the outline/digest. In the Bramble Bush, Llewellyn never advised students to take practice essay exams, which is essential for doing well on them. Find essay questions that have the answers provided, so you can check your work. You may find them, as we did, at the reference desk of your law school library. If not, obtain published materials with sample essay questions and answers from bar review companies. Without practice first, during an exam you will feel like someone trying to play chess for the first time after having only summarized the rules of the game. The essence of legal thinking goes largely unmentioned in law school. Professors typically stay on safe ground, avoid theory, and talk about the nuts and bolts of each case. But the main faculty of mind in thinking like a lawyer is the ability to see concrete facts behind a rule and then the rule in a different set of concrete facts. As we saw in Yare, the rule regarding negligent interference with prospective economic advantage requires imagination to go from its categorical, material, facts to a concrete situation in which it applies, and imagination to go the other direction. That's why the restaurant owner initially missed the significance of the case of the negligent notary. It's hard to see how the 6 general factors that determine a relationship between one person and another, sufficient for a legal duty and tort, in by conja, also fit the example of renovating a restaurant. If people don't see through two-dimensional rules to the third dimension of reality beyond it when studying law, how can they later identify the rule and the facts of life? Students are often puzzled by the facts in an essay question, unsure which rules apply. Imagine what the restaurant owner's lawyer in Yare may have thought to himself. I'm not looking simply at a restaurant owner here, but at her role as a tenant and a third-party beneficiary of a contract between her landlord, the county, and a contractor, Gregory. And the very nature of the contractor's activity seems to create a duty at law, and tort, because it's obvious that if his work is done badly, the restaurant owner will suffer a financial loss, just as the sister did in by conja when the notary botched her brother's simple will, knowing damn well her future fortune depended on him making a will that would stick. The process is called issue spotting in law school. And it often remains difficult for students without strong imaginations. It's essentially seeing a rule's categories amid specific instances of them. Make an analogy to math. Geometry students don't stare blankly at a 3x4x5 triangle, but know it has a right angle, illustrates the Pythagorean theorem, and so on. Taking practice tests in law school will sharpen your ability to see legal rules and the facts of everyday life, which is necessary to get A's on tests. Llewellyn's Digest is the road to B's or C's. The essay questions will trip you up. Imagine if, after reading the 5 cases above, you were given the following essay question on a law exam. A high school chemistry teacher is desperate for money and makes some meth in his basement. One night at home, he and his wife discuss a get-rich-quick scheme. She will sell the drugs that he makes while she tends bar on the weekends. After engaging in their business for several weeks, one night she sells to an undercover cop, gets arrested, and charged with drug dealing. When questioned, she says her husband was the criminal mastermind. And she will gladly testify to that to get immunity. When he is tried for conspiracy to sell drugs, what objection might his lawyer make to his wife's voluntary testimony against him? How would the judge likely rule and why? Please jot down your answer before reading further. This is a typical exam question in law school because it has a twist. You are led down the primrose path of trammel and are invited to explain how the drug-making husband can't escape justice so easily, that the rationale for the marital privilege is weak, and the demands of truth and justice are strong, such that the Supreme Court vested the privilege in the witness spouse alone, so her voluntary testimony, as the facts say, should be allowed over her husband's objection. But notice this hypothetical concerns one-on-one, confidential marital communication, pillow talk, which is privileged according to Blau versus U.S., as stated explicitly in Trammell. So, the material facts are controlled by Blau and not by Trammell. Thus, the wife's testimony should be excluded by the judge as inadmissible. This shows how tricky law school exams can be. They often hinge on one missing material fact. The key to not being fooled was to picture other people in the room when you read about non-confidential, marital communications in Trammell, and to imagine one-on-one pillow talk as confidential and still privileged. Visualization was the key. As you read cases, statutes, rules of civil procedure, and rules of evidence, it's good to imagine how you might use that law on behalf of a client in a hypothetical case. You are trying to go from general rule to concrete instance, easing that pathway in your mind. It will make it easier to do the reverse when a client comes in and tells you all the messy and unique facts of her case.
If you have read the 5 cases discussed above in this book, then you will be very well prepared for your first day of law school. You can relax and see if the speaker says you will learn how to think like a lawyer without describing what that means. If so, you could raise your hand and say, I had a feeling you would say that. But doesn't that term just beg the question of what thinking like a lawyer is? Don't you think it would help to describe the process a bit now? The professor says, no, it's too profound, manifold, and ineffable for any such simplistic thing. You'll have to wait for your classes to start. You say, well, couldn't someone gain insight into such thinking on their own by reading 5 good cases in which legal reasoning is demonstrated? He says, and which 5 cases do you have in mind? You say, oh, let's see, then say very quickly, Trammell, Riggs, Roberson, Buick, and Jair Corp. Then ask him, and which 5 cases might you pick, I wonder? He says, well, I'd have to take some time to think about that. You say, that's all right. I have all day. And the crowd reacts. Now that would be an orientation day to remember. And we like to see our fellow students challenge the professors.